Hello everybody, welcome to part 2 of Declamation and Law, where we are reviewing very interesting concepts that we are writing here on our whiteboard. Remember to ground yourself, be comfortable in the center of your head, behind your eyes. Take a deep breath for 4 seconds, hold it 4, exhale 4. Portrait yourself as an orator, wandering across some streets, palaces of the Tevere, crossing some ancient bridges, or just having meditation on the temple of Hercules Olivarius, then crossing to have your declamation in a forum like in the temple of Portunus. Here the walls and walls of the city, people eagering to hear you speak, because you have very important ideas to mention in your oratory. The reasons behind such a choice on the part of the rhetoricians are not easy to identify. According to the conventional interpretation, they were inspired to identify by the legal regime that preceded the Augustan law, which had recognized the husband's right to avenge his violated honor. But this is an assertion rather than an explanation, nor is the hypothesis of passive imitation of Greek law persuasive, since at least in the context we know best, Athens' similar laws did not permit the killing of the adulterous woman. Remember, these concepts are merely metaphorical, that live in the Sophistopolis of the orators. So if you want to grab them, develop, defend them, or attack them, or be neutral, take your stance. We are thus warranted in posing the question in new terms, revealing different aspects of the controversy on adultery. If the Augustan law as such appears foreign to the rhetoricians, the school texts, and in particular Pseudo-Quintilian Minores, strongly emphasize the motive of justus dolor, or legitimate resentment. Affecting the husband when he has caught an adulterer in flagrante delicto. And justifies a passionate reaction that leads to the death of the two lovers. This law, the one permitting the husband to punish his wife and her lover was written in view of the grief experienced by the husband, and that famous creator and extender of the law wished it to be exercised privately. For example, that it did not require the intervention of the public tribunal. Now this is important because it finds precise reflection in imperial interventions datable to the Antonine age that were aimed at mitigating in consideration of justus dolor, the strictness of the lex Julian in punishing a husband who had executed his adulterous wife in order to redress the damage she had brought upon the integrity of the domus. This is a case of a rescript of Antoninus Pius, according to whom a husband who admits to have killed his wife caught in flagrante delicto can be acquitted of a capital charge insofar as it is extremely difficult to rein in one's own legitimate grief. The justus dolor. In cases like this, evaluating the relationship, if any, between laws of the imperial chancellery and declamatory practice is not easy. If the rescript of Antoninus Pius is the most ancient pronouncement on weakening the lex Julia, it seems reasonable to assume from the fact that the judicial sources do not report earlier interventions. It is chronologically later than the redaction of the minores, which, if are not the work of William himself, nevertheless can be attributed to one of his students, and thus can be dated to the beginning of the 2nd century CE. We can say then that the theme of justus dolor must have been in the air, and that probably both declamation and imperial jurisprudence drew on the same lively debate at the turn of the 2nd century, and the sensibility that was maturing vis-a-vis customary behaviors, where we prefer a lasting resistance to introducing novelties around jus occidendi by Augustan legislation in respect to republican legislation. If declamation is not a direct inspiration for legislative proposals or doctrinal classifications, it is nevertheless a participant in the same cultural milieu, which both mature, thanks again to the rhetorical training that almost all the jurists will have had, and which in many cases will have influenced their later exegetical activities. But beyond the frequent affinity that the logic and practice of rhetoricians show with that of jurists, there is, in our view, a deeper level at which declamation and the law come together. Paying too much attention to the contents of the school laws and to examining their correspondences with laws actually attested in surviving codicing risks, overlooking something crucial: the cognitive abilities and mental habits of those who undertook rhetorical training in their formative years. We have already mentioned the idea of the primacy of the law and of the court as the only site for negotiating social and family conflicts. But there is something else. The majority of the controversia we possess lay out along two dimensions. On the one hand, the definition of the action under discussion, and on the other, the clarification of the laws that guided this discussion, and verification of their applicability to the case in question. These two aspects may coexist within the same declamation, of course. Texts of the first type fall under the so-called status finitibus, where what is at stake is a shared definition of the behavior of one of the two parties, whether the relationship can correctly be called adultery between a woman and a man who until recently had been her husband, whether it is legal to call the killing of a despot for purely personal defense, our famous tyrannies, and so on. In such cases, the fictitious nature of the law that sparks a discussion, or the more or less improbable character of the situation that justifies it, are much less important than the form in which the discussion is conducted and the analytical skills that it helps sharpen. Forms and skills that can then be applied to complex laws and situations from the real world. Same reasoning holds for the second type of texts we have mentioned, those that belong, according to the ancient terminology, under the rubric of contradiction, apparent or real. Between the letter of the law and the legislator intention, or between different laws, and so belong to the category of status legales. Here too, the spurious character of the juridical text on which discussion turns is entirely irrelevant to the skills that one needs to interpret the text. As Petronius satirically remarks, when the claimers finally landed in the forensic context, they may have had the impression of being in terra incognita. A world in which the familiar, habitual themes and characters of declamation were gone, replaced by radically different forms of interaction with the public and with the opposing party. In that context, the obligations and interdictions of praetors awaited them, rather than wizards, lax oracular responses, or stepmothers crueler than those of tragedy, as Quintilian put it. In the schools, everything was simple. In the forum, we must examine documents, testimony, contracts, agreements, obligations, relationships of law, and of acquisition of decrees and responses. Nevertheless, graduates of the rhetorical schools had extensive training in confronting an articulated system of juridical laws, and had developed an aptitude for discussing the individual concrete case, even if improbable, by contextualizing it with that system. Whether the laws at the heart of some controversy were real or fictitious, what counts is the intellectual habits they presupposed and helped shaping. Confronted with the law of a declamatory theme, the student was urged to question the applicability of abstract law to the concrete case in question, to define its extension and limits, to examine the intention of the legislator behind the literal words of a text that might sometimes be vague or ambiguous, to hypothesize possible exceptions and so on. He learned to move with a complex legal system, where two laws could be conflictual and whose combination might lead to consequences both unexpected and unacceptable. The fact that, especially from the beginning of the 2nd century CE, legal innovations often came about through imperial rescript, alongside a more traditional responsa of jurists. And that these often gave responses to individual cases, often as intricate as any school theme, must have made rhetorical training even more relevant to the activities of the interpreters of law. If our reading of the controversies is correct, it follows that in spite of the perplexity expressed by many in this regard, the schools of rhetoric did in fact adequately perform the task they were called upon to do by those who frequented them, and this means their critics have been wrong to focus on the most showy and also most superficial manifestations of that word, missing the deeper significance of rhetorical training. Behind all the severe or overly indulgent fathers and all the cruel stepmothers, all the pirates and bloody tyrants, all the ghosts and phantasms, all the sublime heroism or petty villainy. What they were talking about was real questions of power and wealth. Of justice and equality, of good and bad politics. Of the flexibility of the law and the power of the world. Out of all the overblown discourse, all the verbiage meant for effect, all the literary allusion, there comes forcefully a notion of the law as the only foundation for civil coexistence. And a rejection of any prerogative that claims to be above or free from the law, entirely whether this prerogative is claimed by a father, a tyrant, or a vir fortis. To understand this and to appreciate the contribution that the school controversia give to our understanding of ancient culture through its development over the course of the imperial age, it is sufficient to go deeper than the poppy, seed, and sesame of their words. So this, we have finished the chapter on declamation law. Review. The topics, the themes portrayed on your screen on our whiteboard. Try to start crafting your own declamations. Start with a precept, a law, and then develop for example, the children must support their parents or be imprisoned. And a priestess must be chaste, and the chaste parents, pure and pure parents. That source of law I will be posting maybe 3 to 4 laws, and you will develop using the concepts developed here at our chapter content. We have almost finished the introductory course on Roman declamation. We just need to review some concepts portrayed by Greeks and Romans that are very interesting and very controversial, like for example, the woman who enters in a gymnasium should be punished by death. It should be permissible for mothers to kill their children without due process, and different concepts. Remember that all this violence portrayed, killings, the tyrannies, the befortis, the stepmothers live in our Sophistopolis, in our created Roman declamation world. Reflect on them. Research 2, maybe 3 laws, and create a compelling case. We will be doing that in our next activity on our declamation happenings. That will be posted on our LinkedIn. Thank you. This was lecturer B.A. Marcus Roma. Please have a wonderful rest of the day. Any comments, questions, ideas that you have regarding Roman declamation? How can you continue with all the development of these skills? Please be sure certain Sapir Fortis, Tyrannies to contact me, and I will be glad to assist. See you in the next and final chapter of our introductory course. So we can go to part 2, which is reading Roman declamation, the part of Calpurnius Flaccus, which has very interesting concepts, themes, and topics to develop. Thank you and goodbye.